This is Emma Reckart from Northwest Defenders on behalf of Mr. Hudson, and he is present in court and seated to my left.
Thank you. Good afternoon. Good morning, Mr. Hudson. And good morning, Ms. Anderson. Can you hear us okay?
Yes, good morning.
Good morning.
This is Attorney Shelley Anderson for Mr. Miles Hudson in case number ending in 0362.
Mr. Carter.
Thank you, Your Honor. Just one housekeeping matter before we get started. I know the media who's in person here has probably already made this request, but there was a request in the chat on WebEx from Como, who I believe is only here online, about recording over the WebEx, basically recording the WebEx feed. Just wanted to draw that to the court's attention because I don't know if that was addressed already.
I don't think it was. I'll hear from Ms. Reckert.
Defense is just maintaining our earlier objection at the last hearing to media filming at all. Our objection is that Mr. Hudson's right to a fair trial could be infringed upon, especially if identification becomes an issue here, and that showing his face online or on the news could taint the potential jury pool.
Thank you. Ms. Anderson, are you joining in that request?
Yes, Your Honor.
At this point, kind of based on the whole history of this case, the court's going to allow filming both online as well as in the courtroom. It's clear to the court that there's a compelling public interest in open courts, and the court finds that that interest outweighs any potential trial for defense at this point, based on the procedural posture of this case. So we're on for pre-trial, correct?
That's correct, Your Honor. There's a couple of other housekeeping things that we need to address.
And you're seeking to revoke PR based on some alleged violations, is that correct?
That is correct, Your Honor. The city filed on Thursday of last week a motion to revoke release based on violations of the court's conditions of release.
So before you get there, hold on. And then, Ms. Rickard, I read through your motion to reconsider. The court did indicate to the parties it was going to deny that motion, but I do think I do agree with you that the court's record was deficient. So it's going to make a further record. I don't think that we can proceed on the city's request until the court goes through a constitutional analysis as to whether or not its order is constitutional. Obviously, if it's not a constitutional order, it can't be the basis of adjudication. So the court received the defense briefing in this case. So the court's basically ordered Mr. Hudson not to post on 2 social media sites, Instagram and Twitch. And additionally, the court has specifically limited posting on 2 accounts that were directly related to the alleged criminal activity. For the purposes of this court's analysis, it's going to assume but not concede that this order does implicate a First Amendment right that does require a more detailed record. After reviewing the defense motion to reconsider, it appears that the defense agrees that this is a content-neutral order. The law is content neutral, or an order is content neutral, if it serves a purpose unrelated to the content of expression and does not on its face regulate speech on the basis of its subject matter, topic, or viewpoint. In reality, this court's order is more akin to a time, place, or manner of restriction, which are valid provided that they are justified without reference to the content of the regulated speech, that they are narrowly tailored to serve a significant government interest, and that they leave open ample alternative channels for communication of the information. The order must directly advance a substantial government interest and be narrowly tailored. That is no more extensive than necessary to serve that interest. In this case, it's clear that Mr. Hudson's alleged crimes are related to his pursuit of internet notoriety. His SRT Miles account was used to publish a video of alleged reckless driving incidents. According to the police report, quote, Hudson stated that he had almost 700,000 followers on his social media and that the amount of money he makes on filming his videos of him in his vehicle on the street has paid for his car. Hudson stated, quote, I'm going to keep doing what I'm doing. I'm going to make a career out of this, end quote from Mr. Hudson. Hudson then showed me, the officer, his social media page. The page was in fact SRT Miles, showing the same handle and the same profile picture as him. He then located the account and viewed the videos on. Moreover, he could see that Mr. Hudson was on an administrative page indicating the account belongs to and had access to him on his phone. Mr. Hudson is then alleged, while on conditions of release of the previous case, so the reckless driving case, to have used that same Instagram account to share intimate images of a previous partner without consent. He's then alleged to have live streamed a stalking incident. It's clear to the court that the defendant's attempts at internet celebrity are the driving force behind his alleged criminal conduct. Therefore, the court's narrowly tailored order limiting the rights as part of a pretrial condition of release serves the significant government interest of preventing the defendant from both committing a violent crime as well as interfering with the administration of justice. Under CRRLJ 3.2 D1, the court may prohibit the accused from approaching or communicating in any manner with particular persons or class of persons. This court's order is squarely in compliance with that rule. The court also believes that limiting the defendant's access to a specific digital space provokes similar First Amendment implications of that of an exclusion order to a place or business. That is a non-controversial practice in this court. Additionally, under CRRLJ 3.2 D10, the court has wide latitude to impose any condition short of detention to assure the prevention of interference with the administration of justice and to reduce the danger to others and the community. The court believes by limiting Mr. Hudson's social media access to these two websites that it has able to have a significantly lower bail amount than it would otherwise. Finally, Mr. Hudson has ample alternative channels for communication of this information. There's no content-based restrictions on his speech. I have imposed and will not impose any gag order at this point. He's free to speak to the press at any point. He's free to post on alternative social media sites like Snapchat and Facebook. And in fact, according to the warrant proposed by the city, or provided by the city, Mr. Hudson has already availed himself of that and created a TikTok account. Therefore, the court makes a finding that its order is constitutional and that the defense motion to reconsider is denied. Mr. Carr.
Thank you, Your Honor. I appreciate the thorough record laid out by the court here. We do need to address Mr. Hudson's conditions of release as well as where these cases are going from here. I just want to be clear about one thing here. It's my understanding that the prohibition on the social media sites, Instagram and Twitch, was under cause number 2153, correct? The DV matter, and not the reckless driving cause number ending in 362.
That's correct, at this point, correct.
So the city did file last week, Thursday, motion to revoke release pursuant to CRRLJ 3.2J and or 3.2K1. That was filed last week, Thursday. The court indicated on Friday that it was going to deny the city's request for a $25,000 bench warrant, but ordered Mr. Hudson to be present today to discuss conditions of release. He is present here today, as are both of his attorneys. So we do need to discuss the conditions of release. The city is still seeking the court forfeit the bail that was imposed on July 29th and issuing a new higher bail amount based on violations of his previous conditions of release, which Your Honor just outlined. I'm not going to go through the full motion that I filed here, but I do want to highlight some of the more prevalent points for the court. Number one, I expressed this concern at the last hearing, Your Honor, when we expressed the conditions of release, and we talked about the license plate change for Mr. Hudson, changing it from the designated license plate that was the subject of another condition of release in the reckless driving case to a personalized vanity plate. Suzuki, I believe, was the vanity plate. The city believed at the time that that was an effort to skirt the court's conditions of release not to drive that vehicle with bearing that specific license plate, and that was the subject of a request to change the conditions of release to include the VIN number in lieu of a license plate, which obviously cannot be changed. At the time, defense suggested to the court that the reason that he did that change was for his safety and that he was getting pulled over by police more often because the license plate of the car is what they recognized. I think this is evidence here, Your Honor, the city is providing that Mr. Hudson is willfully attempting to skirt the court's conditions of release and continue to engage in the same behavior that he has been engaging in that was the basis of those initial conditions of release. As outlined in the brief, the name on the Instagram account that was srt.miles changed very quickly after the court inserted those conditions to not .srtmiles. A disclaimer came up on there saying that Miles doesn't personally post there. However, that same Instagram account almost simultaneously started selling a subscriber package for $9.99 a month, as outlined in the brief, including photographs from that account, which promised a number of things, like exclusive access to videos that aren't made public, the ability to get advanced videos that might be posted in the future, as well as I think the most prevalent thing is an Ask Me Anything feature where they could theoretically pose a question that would be assumedly answered by Mr. Hudson. The disclaimer says this is supposed to be managed by a 95 fast pitch or some handle along those lines. However, it's highly doubtful that that's the person who's answering any question that the public is going to be posing as part of the subscriber package. This is clearly a way for Mr. Hudson to continue posting content that will not be available publicly, as well as interact with people who have purchased that subscriber package directly and continue to engage in the same behavior that he has been engaging in the past. Mr. Hudson has also created another Instagram account called alone.miles, in which he has displayed photographs as stories, the kind of media that disappears after 24 hours. There were concerned citizens that took screenshots of that, provided them to my office, which I've included in the brief as well. Those photographs, and there are 2 of them, are of Mr. Hudson photographing his ankle monitor, his EHM ankle monitor that was a result of the court's conditions of release at the last hearing. That is juxtaposed against the car keys, which are very easily recognizable, displayed in almost every Instagram video that Mr. Hudson posts, as well as numerous personalized articles around his apartment bearing the Hellcat logo that he has created for this persona specifically. They match the same designation and keychain that's on his keys, as well as a number of places across his social media. There's no doubt that these are photos of Mr. Hudson posted on a account that is named alone.miles, which, as we all know, Mr. Hudson's first name. Your Honor, he's similarly engaged in similar behavior on TikTok now, in which he has adopted his previous Instagram handle, srt.miles. He's posted videos in which he's engaged in the same behavior, used the same similar vulgar language in all of his other media posts, as well as shown photographs of him actually being taken into custody from this very courthouse just upstairs, I believe in 1103. Your Honor, Mr. Hudson is making every attempt to skirt around the court's conditions of release. He has actually violated them in a number of places by offering this exclusive content, which he is going to be interacting directly with the public on not.srtmiles Instagram handle, as well as his own now personalized Instagram page, alone.miles, which he is posting photographs that disappear after 24 hours of things that could only have been put in place after the court has initially put in place conditions of release, including EHM. Your Honor, we are seeking the court to forfeit the previous bail of $5,000 on the DV case and impose a much higher bail because Mr. Hudson, as he told the police and as he had now shown the court on several occasions, will not stop this sort of behavior.
Yes, Your Honor. So, according to Rule 3.2, before entering an order revoking release or forfeiting any bail, the court needs to find that there was a violation of the order by clear and convincing evidence. And the order in this case, there's kind of 2 sections to it. The first one says the defendant shall not post or stream any content on the social media sites Instagram and Twitch. The second part says no posts, content, or streaming or reels are allowed from the social media accounts SRT Miles and Blitzky from any users. As to the second part of the order, there's no evidence that there's been any content posted specifically from either of these accounts. It sounds like the city is pointing to some sort of like subscribe option. There's no evidence that they've submitted that there has been any content actually posted, so no posts, no stories, no streamed content. And then the city's also not shown by clear and convincing evidence that it was my client, Mr. Hudson, who posted the image that they are talking about under the account alone.miles. As Your Honor noted earlier, and as the city has also noted, Mr. Hudson's not prohibited from posting content to other social media platforms such as TikTok or YouTube, and anyone is able to download a video or an image from those platforms. So it's very possible that he would have posted this image on, for example, TikTok. Someone could have downloaded it and posted it under an account titled alone.miles. There's no information that the city has gotten from Instagram relating to who owns this account. There's no metadata information. And this case, as we can see from the cameras in the courtroom, has generated a lot of media attention. There are a lot of members of the public who would like to see the court find such a violation, as is demonstrated also by the fact that individuals are emailing screenshots to the court. So I would say that it is very possible that someone would have reposted this content, or alternatively that a fan could have created an account and reposted the content. So the city hasn't shown really any information beyond these screenshots from unknown individuals in the public, and defense's position is that that does not meet the standard of clear and convincing evidence, which, as we know, is higher than the standard of preponderance of the evidence. And so we would argue that the court should not revoke any conditions of release under 3.2.
And this is obviously only under the DB cases, so I don't think, Ms. Anderson, I don't believe you're going to take a position on this because this is not your case, correct?
That is correct, Your Honor.
All right. So for the first portion of this, the not SRT miles portion, I agree with the defense. The city has shown evidence that the defendant has created this subscriber information, but there is no specific information or allegation that the defendant has actually posted or done anything. I understand the limitations of what the city is allowed to access, but at this point, I don't think I can find by clear and convincing evidence that the creation of this account or this subscription is actually a violation. Mr. Hudson, I'm going to be super clear with you. Changing the name of your Instagram account or saying for legal purposes that somebody else is posting on it is not effective, okay? I know how this works. This is the account we're talking about. If you post on it, you will be taken into custody. You understand that? Okay. I also am wholeheartedly rejecting the defense argument that somebody else is posting on this. The court's order is that no content is to be posted. I know from the police report, as well as the fact that in open court, Mr. Hudson was able to delete a video that I asked him to, that he has access to this account and could easily change the password. Mr. Hudson, I'm going to be very clear with you. You are on the hook for any account, anything that gets posted to this, and not SRT Miles or your Twitch account. You understand? Anyone posts, you are the person that gets in trouble. So therefore, for the first portion of this, I'm not going to find a violation. However, I am going to find a violation of the court's order for the second portion, which is the Alone Miles account. The court's going to make a finding by clear and convincing evidence that the defendant violated its order. This is clearly Mr. Hudson's ankle monitor. The rug he has matches the one in the not SRT Miles Instagram account. The court might be willing to give the benefit of the doubt, but because it's clear to the court that Mr. Hudson has attempted to skirt the court's orders multiple times through these technical changes, it's going to make a finding that he did violate the court's order by clear and convincing evidence. The court is going to forfeit Mr. Hudson's bail. It's going to reset bail on this case, an amount of $15,000. Mr. Hudson has an active warrant, it looks like, out of Renton Municipal Court. So he'll be taken into custody today on that warrant, or excuse me, on the court's case, with the understanding he also has an active warrant. Mr. Hudson, I don't want to go back and forth with you on this, okay? This is the first time you've appeared in front of this court violating its order. You're going to get taken into custody again today. I can't give you legal advice, but if you come in front of this court with a second violation, it is going to be very problematic. Comply with this court's orders. These go away at the conclusion of your case. I want you to have the opportunity to live the life you want to live, but you have to comply with my orders. The technical things you're trying to do to get around my orders will not work. You have to understand that.
Do you want to tell me something? Do you want to wait till he's done talking?
I'm also going to modify the condition because of this violation and the court's First Amendment analysis. I do believe a modification of the other conditions of release in the other case is warranted. It's just I'm not gonna impose or change bail. Ms. Anderson, are you there?
Yes, I'm here.
Based on the court's analysis, it is going to modify the conditions of release on your case to encompass the social media order as well. So the same order for the other case is now applied to your case. I'm not going to alter any other conditions, take him into custody, or adjust any other conditions of release on that case. Did you want to be heard on anything on that?
Understood, Your Honor.
Thank you. All right. So now this is going to be an in-custody case, condition, or the request, and so, Madam Bailiff, it's $15,000 on the DD case, and then just a slight change of forfeit the bail, $15,000 bail, and then on the other case, it's just gonna be a modification of the conditions, but no change in bail, and that will not be forfeit. Does that make sense? Just on one case. Got it, okay. Mr. Carr, anything else the city believes the court needs to address before, and Chief, just hold tight, please, before we go to the actual substance of this case?
Nothing else from the city, Your Honor.
What's the actual status, or Mr. Riker, do you want to be heard, or what's the actual status on what we're going to do in these matters?
Can you give me one moment, Your Honor?
Your Honor, on my case number,
Yes, ma'am.
ending in 0362, I've submitted an order setting this for trial.
Oh, right.
The parties have not been able to make an agreement on a resolution. I don't believe defense counsel has received an offer from the city, and so we're looking for readiness and trial dates.
Yes, ma'am. Ms. Riker, I'm going to go through the trial set on this one, if that's okay. Or do you need a second?
It's fine.
Okay. All right. So, what do we have for expiration on this trial set? Lower bench, please.
Yes, Your Honor. Your Honor, it looks like the expiration is September 27th, 2024.
All right.
Your Honor,
Is that agreed by the city?
are we operating off the former expiration, Your Honor? Because Mr. Hudson was actually released from custody. When we continued the case at the last hearing, it was a 60-day expiration because he was taken into custody. So I believe it should actually be
I agree.
the end of October.
And he's not being held on any additional bail in this case.
Not that I'm
So
aware
it'll be
of.
30 days from the 27th. Lower bench, can you calculate that for me? Ms. Anderson, does that all make sense from your end?
It does, yes.
Thank you. So I think it's going to be 10/20.
Somewhere around 10/26.
128 is my guess.
That sounds about right, Your Honor. But I'll wait for the
But
court.
Madam Clerk is better at this than me.
Yes, Your Honor, can I get the date for the new,
So what was the previous date? July 20 something?
that was, September 27th. The previous one, so.
No, sorry. So the previous commencement was, I believe, July 20 something. When's the last time you court?
Let me take a look, Your Honor.
And it's going to be 90 days from that day.
Yes.
Thanks. July 29th, does that sound right? Anybody?
Yes.
Your Honor, the
Thank you.
commencement was July 29th.
So 90 days from July 29th, please.
And that would have been, October 28th, 2024.
Perfect. All right, so it'll be October 28th. Ms. Anderson, are you aware of any outstanding discovery that you need at this point?
No,
All right.
I believe discovery has been received.
Thank you. City 135-day trial.
Yes, Your Honor.
Ms. Anderson, do you have any motion dates or motions that you know you want to file at this point?
I'd like to reserve them for the day of trial, nothing of note right now.
Okay, my only request to you is that if you do believe you have like a 3-6 motion or something, just let us know in advance, and if we can get this before the trial, it would be very appreciated, okay?
Okay,
Thank you.
And, Your
do we have
Honor,
a proposed
under-
trial date from the parties?
Under the local rules 8.2.1, I think defense would be required to submit an affidavit within 5 days of today's date outlining any 3-6 issues. Otherwise, they would be presumptively waived.
I agree with you, and that being said, that is the local court rule. However, There's also appellate consequences for
Mhm.
waiving obvious issues, so doesn't sound like there's anything at this point. We can litigate that if we need to.
Okay, thank you, Your Honor.
Proposed trial date.
Do you have the case right now?
So we've got 10/28 for expiration. Do the parties want to go on the 8th of October? I don't have my sheet, Lord Bench, is that available? I don't know. Ms. Anderson, do you have a schedule or do you have a preferred date?
October 8th works for defense, that would be great.
Does that work for the city?
Your Honor, that should work for me and my co-counsels on this case. However, I don't have information about the witness availability for that specific date.
Do you have information for witness availability for other dates?
I don't at all. I was not informed that we were going to be picking trial dates at today's hearing, so I didn't inquire of the witnesses.
Understood. All right, Mr. Hudson, are you going to be available on October 8th for a jury trial? Given a reason why you won't be?
Yeah.
Okay. So we're going to set this for October 8th, 2024, 8:45 a.m. Readiness will be October 4th, 2024, 8:45 a.m. Mr. Hudson, I'm not going to make him MRA. I know he's got a warrant, but at this point, it seems like he's in communication with counsel, at least on some of these, so I'm not going to make him MRA just to try to take something off his plate. I've signed that order.
Thank you.
Thank you, Ms. Anderson.
Yep.
All right, Ms. Rucker, what's the plan for your case?
We submitted paperwork to continue the case for 30 days.
All right. All right, any objection from the city for 30-day continuance?
No, Your Honor, that's fine.
Motion continues granted. Let's set Statler Bench 30 days.
Yes, Your Honor. And for which case was that one, Your Honor?
This is for the one ending in 2153.
That would be 30 days out?
Yes, ma'am.
Your Honor, we can set that matter for the September 16 at 8:45 in courtroom 1003.
September 16th. All right, okay, it's 60th day.
Your Honor, are we changing that expiration date for that one too?
Today will be commencement, and I just need a 60th day for that one, for today.
For today. And that will make the expiration for that case November 11, 2024.
Is that right? 9, 10? I don't think that's right. 60 days?
So 60 days?
Yes, please.
That would be October 11, 2024.
Thank you. All right. I've signed that order. So just so you and I are clear, Mr. Hudson, I really don't want to see you back here another time for you violating my conditions of release.
Absolutely.
Don't say anything. It's probably not a good idea at this point.
Okay.
I just want to be super clear with you on that. For your reckless driving case, I'm modifying my order to incorporate the social media, the Instagram, social media, SRT miles or not SRT miles, whatever you want to call it, that account as well as for Twitch is getting incorporated over to that. Just want to remind you as well that that vehicle with that VIN is not allowed on any public roadway regardless of who's driving. You're the person that gets in trouble for that. For the other case, the bail's been forfeit. You will be taken into custody today. You also have a $25,000 warrant out of Renton Municipal Court. I don't know what they're going to do with that. They probably won't confirm it, but they might. That's in between what's going to happen to you in the jail. My orders are pretty clear. You can go do other stuff. I'm not limiting that, but please don't come back in front of this court with another violation of this order. I am actively trying to tailor this in a way that keeps you out of custody, but when you violate them, it just gets you right back in the same place over and over again. Okay, but you have plenty of outlets. Use those other outlets. Don't violate this court's order.
Can I say something, Your Honor?
if you'd like to, I would really advise you to consult with your attorney before you do.
Absolutely. I just wanted to say for the photo they're talking about was posted on TikTok, Your Honor, and I did understand what you were saying with the don't post on that. That's why I went straight to TikTok. I do feel like someone's like malice intent towards me.
Okay. All right. I mean, listen, that's a risk that you run because you put me in a position where I've got to make a decision, right?
Mm-hmm.
And maybe I made the wrong one. I don't think I did, to be frank with you, based on everything that you are alleged to have done and your behavior in this court. I don't think I'm wrong. But remember, if you post stuff on the internet and somebody takes it and tries to impersonate you, you force me to make a decision, and I might not make the right one. So that's a calculus that you've got to make as you kind of navigate this. All right. I think we're ready. We'll get you some paperwork. I have to redraft an order for conditions of release. Chief, I think we're good to go.
Thank you. Appreciate it. Aaron, do you need anything else from the city on this?
No,
these
I'm
cases?
good.
All right, thank you.
Ms. Riker, do you have any more cases? Can I get you out of here?
I don't have any in this courtroom.
All right, good luck. Thank you.